Hi, I'm Todd Ortscheid, CEO of GTL Real Estate. This is the third in a series of videos that discusses your lease agreement paragraph by paragraph in an effort to help you better understand your lease. This video will go over the third page of your lease. We've already talked about delivery of your move-out statement, which is how this page starts off. So we'll go to the next item, which talks about how the security deposit is held. There's a lot of fancy legal language here, but I'll keep it simple. First thing to note is that GTL Real Estate holds the security deposit. If you originally rented from another company or from the landlord directly, then we get that deposit transferred to us ASAP and almost always within 30 days. We want to make sure that we hold the deposit in our trust account so that your money is handled appropriately in accordance with all state laws and regulations. If you rented from us from the beginning, then we placed your deposit into our trust account as soon as you paid the deposit. Either way, your money is safe and sound in our state registered trust account. Now, if management were to somehow transfer to someone else in the middle of your lease, which is a rare circumstance, then two different things could happen. If management is transferring to another licensed real estate brokerage, then we'll transfer the security deposit to them so that they can hold it. If management is transferring to the landlord himself, then we continue holding the security deposit in our escrow account until you vacate, and we still conduct the move-out inspection. All of this basically means that we take the security of your money very seriously. We want to make sure that the money is safe and untouched until you move out. Finally, this section talks about what happens if there is a dispute over the security deposit when you move out. Basically, we're the decision maker on this. We do not allow the homeowner to make decisions about what happens with your security deposit because, frankly, they're not the trained real estate professionals. Our licensed staff makes all final decisions about what happens with your deposit and anything charged against it for damage, and we always comply with all laws, regulations, and ethical standards. If there is a dispute and we can't figure out which side is right, then the lease says that we can do something called interpleading the case, which basically means that we ask a judge to make the decision. This is incredibly rare, and we've never had to do it in over a decade in business, but it is there if we need it. The next section talks about failure to move in, and since you're already a tenant living in the house if you're watching this, that doesn't really apply, so we'll move on to the next section. The last part of the security deposit language talks about sale of the property. We found in years past that when a landlord sold a property that had a tenant in place, there was always a big mess created with figuring out who was going to hold the security deposit after the sale. So we decided to make it really easy by putting a provision in the lease that says if the landlord sells the property, your security deposit automatically gets returned to you. The next section talks about utilities. This section says that all utilities are your responsibility unless the lease specifically says that a particular utility is paid for by the landlord. The lease says that you're required to keep the utilities on during the entire term of the lease, including through the last day when you move out. In fact, if you move out a few days early, you still need to keep the utilities on through the last day of the lease agreement. This ensures that the utilities don't get shut off for a few days between tenants. Finally, the lease says if you don't transfer the utilities into your name and the landlord or GTL keeps getting a bill, then you'll be charged not only to reimburse the cost of the utility bill, but also an additional $25 admin fee. So if you're a new tenant, make sure you get those utilities switched into your name ASAP and make sure to keep them in your name all the way until the end of your lease. The next paragraph in your lease talks about the move-in inspection. There are two ways we can do a move-in. Number one is the old-fashioned way, where we walk through the property with you with a paper inspection form, and we both sign the form right there in person. We still do these on occasion, but we generally prefer to use option number two, which is the self-move-in process. With that process, we conduct the move-in inspection ourselves prior to the move-in date. We fill out the form and usually record a video, and then send you the form for electronic signature prior to move-in. This is the preferred process because it's easier on everybody. We can do the inspection on our own time, and you don't have to work your schedule around ours to be there at the property for the inspection. But either way, we'll both end up signing an inspection form that lists everything that's wrong with the property. This protects you at the end of the lease so that you don't get charged for any damage that was already there when you moved in. Next, the lease mentions something called a property disclosure statement. This is a form that is generally only used in home sales rather than rentals in our states. So this paragraph just says that the form is not attached to the lease. That's it for this video. Next video, we'll talk a bit about maintenance and upkeep responsibilities and cover everything on page 4 of your lease. If you have any questions about the items covered in this video or anything else, please send us an email at support@gtlrealestate.com.